There was a recent case example where my client was suing a business owner, and I won't go into the details of it because they're private, but needless to say, the business owner owed our client about, I think it was around about, from memory, $93,000. So still within the magistrate's court range, because the magistrate's court's got the jurisdiction up to 100,000, and it's quite often a cheaper and much faster jurisdiction to litigate in if you can. We issued a letter of demand. In the letter of demand, we set out our client's case in detail, why our client had good prospects as sex, and why they were going to likely lose the case. And at the end of the letter, we basically pointed out, well, here's our cost to date. Here's the sum of $93,000 that's required to be paid, and that, if they're prepared to pay, a negotiated amount of costs, and the $93,000 will forego any interest claim, and we won't bring the proceeding in the magistrate's court. And then ultimately, this business owner had probably been through this before, made the intelligent decision to accept the offer, and in fact, in that scenario, he offered to pay in instalments, but large instalments. It was about $10,000 a month, and we ultimately talked to our client and said, look, if you take into account all the time and costs involved in litigating and what they're offering now, and yes, it's instalments, it's a bit frustrating, but you're going to save yourself going to court. You're going to save yourself paying us excessive amounts of legal costs. You've got a really good outcome, and effectively you've got a settlement agreement. We entered into a settlement deed, so if they default on that, you can apply for judgment in the court anyway, and you can skip the whole litigation process fairly easily. So if a defendant is prepared to come to the table and make an offer that's reasonable, then quite often that those things can be accepted. But it's not going to be the same approach for every case. Every case is going to be treated on its merits, and that was just a particular situation involving a debt. But I thought I'd give you a case example. Have you had yourself, Rodrigo, any examples recently of dealing people involved in debt recovery matters, or just trying to recover money generally?
Yes. These examples or these sort of cases tend to come up more frequent than one would expect. The unfortunate reality is that there are people out there that carry out the services and they don't get paid, and then they come to me somewhat frustrated, saying, "But Rodrigo, I've done the work. I just want to be paid for what I've done. I just want what belongs to me. I don't want anything more." So I've had an electrician recently. He carried out a job, and I think the invoice was roughly $50,000. And the construction industry at the moment is going through a tough time. And the homeowner knew to just ignore, and sometimes it is not until you get a lawyer involved drafting a letter of demand that then they start to engage in negotiations. And as you said, more often than not, they don't have the lump sum sitting in the bank account, but they are willing to entertain negotiations and enter into a payment plan, which arguably could have been put forward much earlier in the piece, but it's not until you exert a bit of pressure.
Push the button.
That's right. Yeah.
Push the button.
So, and I also think that letters of demand are a good way to protect our clients and also flesh out, which I think will bring us to our next point as to whether or not there are any genuine disputes in respect of the debt.
Well, that's a good point you make, Rodrigo, because the letter can be a good way to just open up the conversation and start the communication. And number two, it can be a good way to get a response. Sometimes there's no response. They're blocked. There's a wall. You're trying to get your money, and there's a wall of silence for months or years, and it's a good way to prompt a response. Well, why aren't you paying this? Is there an issue with the invoice? Was there an issue with the services, the goods? Are you disputing the contract? Or what is the problem? Let's start talking about what exactly your case is, because you're going to have to put a defence on if we go to court anyway. So tell us your position now. Let's even have a without prejudice discussion confidentially. Let's work out exactly how we're going to resolve this. What is your problem? That's the sort of things that I'm thinking with with letters of demand that can come out of it, because, it's only going to keep going. We've seen a 63% spike in insolvencies in Victoria in this past year alone, the highest in the country, and that's been well documented in the media. So it's a lot of unpaid invoices, failed contracts, personal guarantees. Could be landlord, supplier, contractor, in any industry, construction, retail, hospitality, you name it. So there's a lot of issues going on at the moment. I suspect this is going to be a legacy issue that our state's going to be facing, and also nationally, because we do deal with clients nationally as well in different states and territories.